I'm Nivedita Raje, and let's continue with our exercise passage solving. So today's passage is based on a very interesting provision of Criminal Procedure Code. Good evening everyone. I see that there is a question relating to surrogacy. Well, if you're still present in the class, surrogacy basically is two people who are not able to conceive a child on their own biologically. So what they do is they get someone else to do it, right? So the male semen is used and it is, fertilized artificially, the male semen and a female egg. The zygote is created artificially and then that zygote is implanted in another woman's uterus. क्योंकि नेचुरल प्रोसेस है, किसी वजह से अगर एक लेडी बच्चे को कंसीव नहीं कर सकती है तो उसको जाइगोट बना के जो एक फाइनल जो जाइगोट होता है जो बाद में ग्रो होके फीटस बनता है उसको किसी ऐसी यूट्रस में इम्प्लांट कर देते हैं जहाँ पे वो ग्रो कर सकता है, क्योंकि वो पेरेंट्स की जो मदर है उसमें नहीं कर पा रहा है, राइट? एंड so this is what surrogacy is, basically asking someone else to carry your child because you cannot carry it yourself. Now surrogacy is definitely allowed in India. Yes, surrogacy is allowed in India. Surrogacy पे bill है, but surrogacy is allowed in limited terms. जैसे commercial surrogacy allowed नहीं है, which means that you cannot really rent out a uterus, right? You cannot pay a woman to carry your child. No. It can only be with the person you are already familiar with. और बहुत सारे अलग अलग provisions हैं. इंडियन सिटीजन होना ज़रूरी है, फॉरेनर्स आके सरोगेसी नहीं करा सकते, कमर्शियल सरोगेसी अलाउड नहीं है, सिंगल वुमेन सरोगेट नहीं कर सकती, अनमैरिड नहीं कर सकती, और a lady needs to be a mother before she surrogates another child. So it is definitely allowed in India, but with many limitations and restrictions. Okay, so let us move forward. Now everyone knows that we have launched comprehensive courses of both 24 and 25. Now these comprehensive courses can be availed by a free day trial. So in case you wish to know what happens in those courses, you can access the course by unlocking it for 3 days. You get it for free. You can attend as many number of classes as you wish and you can see what we do. और आप एक informed decision ले सकते हैं. I have actually discussed surrogacy not once, multiple times. In fact, surrogacy पे मैंने passage भी करा रखा है. जैसे ये passage आप करने के लिए आए हैं, इससे related passage तक कर चुके हैं हम surrogacy पे. तो surrogacy is not something that we haven't done before. We have done it at least twice, thrice. So if you look for surrogacy, if you look at this entire series, you'll find passages relating to surrogacy only. Okay, we don't have to do it. I have already done it. Now this is the passage. It is based on a recent ruling of Allahabad High Court. The case name is 𝗟𝗲𝗴𝗹 versus State of Bihar, and please, that is the case that they have referred to. Precedent है और उसी precedent को use करके इन्होंने इस case में ruling दी है. But the case is not as important as the provision that is an issue, which is section 41 and 41A of the CrPC. Please read it. It is important. Let us start. Let me know when you're done. Are you done? Everyone? Okay, I believe that you are, so let's move on. The arrest should be the exception where the offence is punishable with less than 7 years imprisonment. अगर 7 साल से कम, अगर जो चार्ज लगा है, जिस ऑफेंस का चार्ज लगाया गया है, the offense that is being alleged, if it provides for an imprisonment which is less than 7 years, then arrest should not be a compulsion. It should not be resorted to unless absolutely mandatory. Done? Okay. अब इसको पढ़ना है जैसे ही whenever you see a definition or a section being defined or section being properly listed in the passage, you immediately underline it क्योंकि question आएगा ही आएगा उससे. So यहाँ पे section 41A defined है, provides that in all cases where the arrest of a person is not required under section 41 clause 1, when police may arrest without a warrant, the police shall issue. Shall का मतलब है it is mandatory for them. They cannot really do what they want. They have to go by the provision. They don't have a discretion. Shall issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a crime, a cognizable offense. Cognizable offense basically is a kind of offense where the arrest can happen without a warrant. किसी भी आदमी की आर्टिकल 21 को डायरेक्टली इन्फ्रिंज करने के लिए ज़रूरी है कि आपके पास लॉ की परमिशन हो, राइट? तो इसीलिए कोई भी अरेस्ट बिना वारंट की नहीं की जा सकती. तो जब अरेस्ट बिना वारंट की नहीं हो सकती या कोई ऐसा ऑफेंस है जिसमें अरेस्ट बिना वारंट की नहीं हो सकती, उस तरह के ऑफेंस को नॉन कॉग्निजेबल ऑफेंस कहते हैं. लेकिन कुछ ऑफेंसेस बहुत सीरियस होते हैं जैसे रेप, डेथ, राइट, अबेटमेंट टू सुइसाइड. तो इस तरह की सीरियस ऑफेंसेस जिसमें पनिशमेंट 7 ईयर्स से ऊपर है, 10 ईयर्स है, लाइफ इम्प्रिजनमेंट है, डेथ है, तो वहां पे अरेस्ट बिना वारंट के भी की जा सकती है और इस तरह के ऑफेंसेस को कॉग्निजेबल ऑफेंसेस कहते हैं, राइट? सो सेक्शन 41 बेसिकली लेज डाउन द directions that a police has to follow, officer has to follow in case there is an arrest that needs to be made without a warrant. So an arrest can only be made without a warrant when it is a cognizable offense to appear before him or at such other place as may be specified in the notice. तो अरेस्ट करने से पहले पुलिस को नोटिस इशू करना पड़ेगा, राइट, उस आदमी को जिसको उसे लगता है कि मुझे अरेस्ट करना चाहिए या कोई सस्पिशन एग्जिस्ट. ओके, आई एम सो सॉरी. So basically what I'm saying is that where a person can be arrested without a warrant because he has committed a serious crime, we call that offense a cognizable offense. But if an arrest can be made only with a warrant, then we call it a non-cognizable offense. So this section 41 clause 1, it makes it mandatory for a police officer to issue notice to a person before he is going to arrest him. So before he makes a decision to arrest him, because it is necessary, because there has been a commission or a charge of a cognizable offense and there is a reasonable suspicion that the person might have been involved or a person might be the criminal himself. So if a police officer is satisfied that this person needs to be in custody because he has committed a cognizable crime or he has an involvement in the commission of a cognizable crime and he needs to be in custody for investigation purposes, so before he takes that decision to make an arrest, he needs to first speak with him. So a notice is issued to a person who would appear to a place that the police officer directs for a preliminary kind of an investigation, and after that the arrest can be made if the police officer still deems it necessary. Okay. Section 41 clause 1 clause A empowers the police officer to arrest a person without warrant when a cognizable offense is committed by a person in the presence of the police. So if a police officer witnesses a crime himself and it is a it is a cognizable offense, then he can arrest that person immediately without issuing any kind of notice, and he can do it without a warrant, right? So I already explained you everything, so I don't think you really need to ponder over it. Please read. Are we done? Good. These are the other conditions on which an arrest can be made without a warrant, right? So what are the following conditions? To prevent further offense, if a police officer feels that, if a person is left without a custody, if a person is allowed to go free, he may commit another offense. So in order to prevent another offense, he would arrest him. For proper investigation, for investigational purpose, to figure out the real story of the crime and everything, a person can be arrested. To prevent tampering with evidence. So if there is an apprehension that if a person is let loose, he might try to tamper or disturb the evidence, remove the evidence. That is what it means. To prevent inducement, threat, promise to anyone related dissuading from disclosing facts. So if there is a witness, that may be an eyewitness, or if there is a person whose testimony can actually lead to something significant, that person may be dissuaded, may be threatened, may be manipulated. So in order to prevent that, because sometimes in a serious case, when a person comes from a influential background, there's a high chance that he may try to manipulate the witnesses by offering them either threat or money or something like that. And it's very easy to sway people, and that is the reason why people are arrested beforehand, so that cannot happen. And the last is when presence before the court cannot be ensured unless the person is arrested. If there's there's a chance that the person might have abscond. Right, he might run to another country, and then procurement of that person's presence would be difficult, and unless that person is present, you cannot really do anything, you cannot punish him, you cannot retrieve anything from him, and the case would come to a halt, which is not practical, it is not desirable. So if there's a chance that the person might flee to another country, might abscond from the jurisdiction or something, then that person can be arrested. Right, all of this generally happens from information. The person is selling the property, selling his shop, trying to clear out, wrap it up everything. What does it mean? He's trying to wrap it up so that he can run away. So based on those informations, a police can make a required decision. Done, everyone? Shall we move forward? समझाई दिया मैंने. So that's it. Let's go to the questions. A police officer receives a complaint that a man has been threatening his neighbor, which is a non-cognizable offense. Is the police officer authorized to arrest a man without a warrant? Is he? I already explained this. So is he authorized to arrest that person without a warrant? Anyone? He is? Dhananjay, quite to the point. He is not. I told you. A person cannot be arrested without a warrant if he is accused of committing a non-cognizable offense. A police officer cannot do it. Right? So the options of yes get eliminated automatically because the police officer is not authorized to arrest a person without a warrant. He needs a warrant. The answer to this is no. Now we'll look at the options that say no. No, because the offense is not cognizable. No, because the police officer does not have a reason to believe that the man has committed the offense. The answer is B. Very good. Exactly. The sole reason of not arresting that person is because he has committed a non-cognizable offense. And a person who has committed a non-cognizable offense cannot be arrested without a warrant. So B is a very simple, straightforward answer. Okay? Moving on. According to Allahabad High Court's observation, which sections of CrPC and the Supreme Court's directions are investigating agencies and their officers duty bound to comply with? This was there in the first slide itself. Anyone? Apologies. And the answer is B. Absolutely correct. The answer is B. 41 and 41A. It is right there. 𝗟𝗲𝗃𝗃 Kumar versus State of Bihar. On the scope and objective of section 41 and 41A, it is obvious that they are facets. Facets basically means categories. Facets are avenues, like they're part. Facets basically means part. They're part of Article 21. They are incorporated in CRPC so that Article 21 can be protected. Right, so they are parts of Article 21. That is the reason why they have to be followed by every member of an investigating agency. So B is absolutely correct. Very good, guys. Under section 41, clause 1, clause B, clause 2 of the CRPC, what conditions must be satisfied for the police officer to arrest a person? To prevent further offense, to ensure the person's presence before the court, to prevent tampering with the evidence. Very easy. It's very easy. Okay, so Garima Chaudhary is first to answer. She's actually the only one who's answering. Shivangi, right? Iram. Who else? Then I have Ramesh, Dhananjay, Sunita, Namra, Nandita, Tulika. Absolutely correct. Yes, D is the correct answer. All of the above. So we have a workshop on 16th of July, guys. CLAT Success Blueprint, Mastering Strategies for 2024. So this is a workshop that Abhimanyu sir is conducting, and he'll give you strategies where you can, which you can use to, what should I say, to cement your preparation. Right, so please attend this workshop. It is going to be free of cost, but you need to register for it, and it will happen on this Sunday at 6 p.m. on BYJU'S exam prep portal. Okay? So D is absolutely correct. Now, question number 4. A police officer receives a complaint that Tarun has committed robbery. The police officer has reason to believe that the complaint is true. Okay, he has a reason to believe complaint sahi, it is true, and the police officer also believes that the person is likely to commit further robberies. Can the police officer arrest Tarun without a warrant? The answer to this is, first decide whether the answer would be yes or no. Whenever you face a question of yes and no, which are pretty straightforward. Yes, we have a newspaper reading class at 6 p.m. We have a newspaper reading class at 6 p.m. I shall be conducting it on BYJU'S exam prep portal itself. The answer is yes. Yes, he can arrest Tarun without a warrant. Right? Because he has committed robbery. Robbery is a cognizable offense. Arrest can be made without a warrant. So yes is the answer. Eliminating the options of no. Now we are left with B and D. Let's see which is the most appropriate. Yes, but only if robbery is punishable with imprisonment of less than 7 years. Yes, the police officer can arrest the person without a warrant. B. The answer is D. Robbery is not punishable for less than 7 years. Robbery is a serious crime and he can arrest. Actually, the option could have been better. Yes, the police officer can arrest the person without a warrant. It is very simple. He can arrest the person because all the requisites are fulfilling. The person has committed robbery, which is a cognizable offense. Police has enough information to believe that he was in fact a robber, and he also believes that he may commit another robbery. So he has all the reasons. So everything is very evident. So he can make an arrest without a warrant. It is very simple. The answer is very simple here. Sometimes the simplest answer is the correct answer. You don't have to complicate things just because they seem more attractive or they have too many words. Okay? Question number 5. What is the purpose of issuing notice under section 41A of the CRPC? To warn the accused about the consequences of their actions, to provide an opportunity for the accused to present their side of the story, to direct the accused to appear before the police officer or at a specified place, to gather additional evidence against the accused. Namra, I discussed this in the first go. Cognizable offences are those offences for which a police officer can arrest the offender or the suspect without a warrant. The correct answer is, everyone, C. Very good. Yes. There is no hidden agenda. The only reason why the police wants him to appear is to appear. After appearance, what does the police officer wants is subjective. He definitely cannot, manipulate him or threaten him or make him submit or make him confess. Obviously not. It is only a part of investigation the police officer wants to meet, and that is it. The examples are more than 100. I cannot give them. Cognizable offences, there is a list given at the end of CRPC, the BEAR Act. You can see that list. But yes, serious offences are cognizable, such as, rape, murder to begin with. There are many others. A police officer sees a person committing theft, a cognizable offence, in his presence. Can the police officer arrest the person without a warrant? The answer is yes, obviously. So we are left with two options, A and C. Now tell me, same reasoning. Can he arrest without a warrant? Can he? The question is very straightforward. Can he? Yes or no? And now you decide. Very good. The answer is A. Exactly. Yes. It's very simple. The aftermath is unnecessary. Yes, the 7 years condition and this and that. We're not concerned with that. The question asks you whether he can arrest. And yes, he can arrest. 7 years thing is, 7 years से ज़्यादा punishment अगर होता है तो मतलब offense serious है. ठीक है, तो और वहाँ पे कस्टडी भागने, मतलब एक बंदा अगर इतना सीरियस ऑफेंस कर सकता है, सिंपल इसका ये है, इफ अ पर्सन हैज कमिटेड एन ऑफेंस व्हिच इज पनिशेबल फॉर मोर देन 7 years, which is a long time, then the offense is really serious in nature and the person is not an ordinary criminal. There is a very high chance that he would be a hardened criminal who needs to be arrested as soon as possible. A person who has committed an offense which is less than 7 years and it is cognizable, even when it is cognizable, for example, let's say, when should you choose? When there is a question that is asking you something like that. ठीक है, जब क्वेश्चन आपसे इस तरह का कुछ पूछ रहा है, क्वेश्चन क्या, देखो पैसेज, हाउ इज द 7 year कंडीशन मेंशन्ड इन द पैसेज, लेट्स रीड इट वंस. It's taking some time. It was a long passage and we have done a lot of questions. 41 clause 1 clause B provides for arrest by police on receiving a reasonable complaint that or has suspicion of cognizable offence having been committed which is punishable with imprisonment of less than 7 years or which may extend it to 7 years if the given set of conditions are satisfied. Basically, cognizable offences, the simple definition of cognizable offences is the 7 year thing. So if a person has committed an offence which is, whose penalty is more than 2 years, then generally it is considered as a serious offence or a cognizable offence. If the penalty increases or elongates to more than 7 years, then the offence becomes a heinous offence, जिसका punishment भी ज़्यादा है और उसको seriously लेना पड़ेगा. It needs to be taken more seriously. The criminal cannot be an easy-going person. He would be a hardened criminal and stuff like that. इसके अलावा what do we have? Anything related to 7 years? Not here. Anything related to yes. It may be noted that as per top court's judgment, the arrest should be exception, where the offence is punishable with less than 7 years of imprisonment. So if the act says, or if the punishment of the offence is less than 7 years and the offence is cognizable for some reason, क्योंकि offence थोड़ा serious है, या फिर let's say a person has stolen items and the items were not that expensive, only worth rupees 2,000, 4,000, then the theft is a normal theft, right? But theft is a cognizable offence. The punishment to this offence would be less than 7 years. अब यहाँ पे वो एक मामूली चोर है. The thief or the criminal is an ordinary criminal. He hasn't done anything significant or too serious. Although he has committed a crime, theft is a crime. But if you consider all the aspects, it's not that big of a crime. 4-5 हज़ार का item चुराया बस. अभी even when the offence is cognizable, the punishment is not that much. So even the law is saying कि भाई crime उतना serious नहीं है. The crime is not that serious. So if you can avoid arrest, then avoid arrest. You arrest only when it is absolutely necessary. That is what the court said कि भाई custody में मत लो just because the offence is cognizable. Take a person into custody only when the other conditions are satisfying. What are the conditions? We already know. Prevent the tampering of evidence so that he doesn't elope. The punishment is more than 7 years or up to 7 years, something like that. So unless there is a proper, mentioning of the fact in the question that he has committed theft, which is cognizable but punishable for less than 7 years, then can the police officer arrest? The answer is yes, he can arrest. The Supreme Court said that he should not. There is no mandate. It is still a discretion. ठीक है, सुप्रीम कोर्ट ने कहा है कि उसे करना नहीं चाहिए. कर सकता है वो, क्या वो कर सकता है? हाँ, वो कर सकता है. वो करना नहीं चाहिए उसे. कस्टडी में बस यूं ही मत लो उसे, बस क्योंकि तुम्हें अरेस्ट करना था. डोंट अरेस्ट फॉर द पर्पज ऑफ अरेस्टिंग. डू इट बिकॉज यू हैव अदर प्रॉपर रीजंस. दैट इज व्हाट द सुप्रीम कोर्ट सेड. वी हैव डन नंबर 5, वी हैव डन नंबर 6. ओके, ए हो चुका है. Question number 7. In which of the following judgment the Supreme Court held that the arrest should be the exception where the offence is punishable with less than 7 years? We already know. The answer is everyone. It's very easy. Good. Anish Kumar versus State of Bihar. Okay, Anish Kumar, the law is not saying it. It is a Supreme Court interpretation. Supreme Court is saying that you should not do it. Okay, the person might have done it under an influence. Somebody might have asked him. He might be an underage person. It might be his first time doing something. You keep him with hardened criminals in jails, he would become a proper criminal. Don't do that. Don't arrest it. Don't arrest him unless absolutely necessary. So yes, B is absolutely correct, guys. Very good. Last question. Which of the following statements can be concluded from the information given in the passage? Section 41 and 41A of criminal procedure are facets of 14, facets of 19, facets of 20, facets of 21. Again, too simple actually. What is the correct answer? The correct answer is very good. Yes, exactly. D. D is absolutely correct. They are facets of Article 21, right to life and personal liberty. Right, so unless right to life and personal liberty, you understand how significant and sacrosanct that fundamental freedom is. So if you are violating a person's right to life and personal liberty, you better have a good reason. And if you don't violate it. Right, so D is the correct option. And that's it for today, guys. I hope you enjoyed this. This is a regular exercise. This is a regular practice that we do every Friday. Make sure that you are attending these sessions. They will help you a lot. हो सकता है इसी में से कोई सेशन या पैसेज आ जाए आपके एग्जाम में सीधा और तब आपको ये सेशन याद आएंगे कि मैंने प्रैक्टिस कर ली इसलिए इसको यूज करना. Now, I have already explained the difference between cognizable and non-cognizable offense. So can you please, rewind the lecture and watch it. Okay, so please watch these sessions. They happen every Friday at 4 p.m. and we have another session at 6 p.m. which is, you know, the newspaper reading session, where we shall be analyzing the newspaper from a legal point of view. Again, something very important. A passage might straight away picked up from the Hindu or any newspaper and be there in your exam. So it will help you a lot. It is free of cost. 6 p.m. BYJU'S exam prep portal. Thank you guys. I shall see you again very soon. तब तक सब अपना ख्याल रखें. Take care. Bye bye.